Well, good day, everyone. I think it's time to call the meeting to order. Welcome everybody to our webinar, Notable Issues in Domain Name Disputes. My name is Barry Penner. I'm the Managing Director of the Canadian International Internet Dispute Resolution Centre, which is a wholly owned division of the Vancouver International Arbitration Centre, based, as the name would suggest, in Vancouver, British Columbia, but we operate globally through our platform. Very pleased today to have you join us for this important discussion about developments in the issue, the topic of domain name disputes. And very pleased to be joined by some leading practitioners in the area. We have with us today Tina Cicchetti, who calls originally from Vancouver, British Columbia, and is a part of Vancouver arbitration chambers, and is known, I think, quite widely as a leading arbitration practitioner, as an independent neutral, is also associated not just with Vancouver Arbitration Chambers, but also is a member of Arbitration Place in Toronto, as well as one of our CDRP panelists. She's a member of the Executive Committee of the Board of Directors of the California International Arbitration Council, a member of the ICC Commission of Arbitration and ADR, past chair of the International Arbitration Committee of the Canadian Chamber of Commerce, ICC Canada, a board member of the Western Canada Commercial Arbitration Society, former president, current advisory board member of the Young Canadian Arbitration Practitioners, and a member of the ICDR Canada Advisory Committee. Tina was appointed by the Government of Canada as a member of the NAFTA 2022 Committee. You can find out lots more about Tina by referring to her website and or just checking her out on Google. Also today, pleased that another presenter is Doug Eisenberg. May not need much of an introduction, but I'll give you one anyway. He's an attorney and founder of the Giga Law firm based in Atlanta, Georgia. Doug is a recognized leader on internet law, domain name panelist, and a frequent author and speaker on internet legal issues. He has served as an adjunct professor of computer and cyberspace law. The World Trademark Review said that Doug is a whiz on all things to do with the internet and internet law and domain names. And the Atlanta Business Chronicle has called him an international authority on internet law. He's included in the 2021 edition of Best Lawyers in America for Technology Law, and he's worked with clients on domain name transactions and disputes since 1996, and today represents some of the world's largest and best-known brands with respect to their internet legal matters, including the largest complaint ever filed under the Uniform Domain Name Dispute Resolution Policy, UDRP, and we'll be hearing more about UDRP in a few moments. And for more information about Doug, I invite you to visit his website, which is giga.law. Turning to our presentation and moving forward, the scope of the webinar today, just to give you an idea of the topics we'll be covering, we'll be looking at our role, the center's role, in administering domain name disputes under both the CDRP, that's the Canadian version, and the Uniform Dispute Resolution Policy administered by ICANN. The UDRP overview will be provided, as well as for the Canadian version, and we'll look into a number of actual case studies to get a better sense of current developments. So one of the important things of this webinar, we'll be looking at the legal tests, the underlying cases that facts and law that you need to marshal in order to be successful and or defend a claim. And as well, we'll be taking a look at some of the most recent talk about us for a moment. We are the most recent institution that's been accredited by ICANN to administer UDRP disputes. And we were approved in ICANN back in 2019, and we formally launched in November of that year. So we are the newest kid on the block. We're one of 6 organizations so accredited by ICANN. And if you haven't yet had a chance to take a look at our website, this is what the main page would look like. This is what will greet you if you go to our address, ciidrc.org. And once you enter through that portal, you're confronted with a choice because we are serving both CDRP disputes, the Canadian .ca domain name, and UDRP. So at this point, when you get through our website, you have an election to make. And when you make your choice, you then have an opportunity to file a complaint and upload your documents and marshal your arguments on right through this portal, and similarly to respond to complaints. So what we have developed is an online platform to try and speed the process, reduce the amount of paperwork, and just reduce everybody's administrative burden. So that's a brief overview of the Canadian International Internet Dispute Resolution Center. We have been handling .ca name disputes since 2002. So we've been at that for about 18 years now. But as mentioned, we're more recently accredited by ICANN to handle UDRP disputes. So at this point, I think it's up to me to turn it over to Doug.
Great, thanks, Barry. And let me just make sure I do this properly to get my slides pulled up. But while I'm doing that, I'll say, obviously, it is an honor to be with everybody today. And I guess I can maybe just begin by saying that really today's presentation is quite timely because domain name disputes are at an all-time high, even almost 22 years after the UDRP, the Uniform Domain Name Dispute Resolution Policy, Barry, that you referred to, went into effect. And what that means really is obviously the problem of cyber squatting is just not going to go away. So I thought really that would be the best way to begin by setting the table a little bit and just providing a brief overview of domain name disputes in general and how domain name dispute policies work before we move on. And then I will move on to focus on a handful of specific UDRP decisions from last year from the CII DRC. And I'll try to explain why they're important and what lessons they hold for trademark owners and domain name registrants in general. But I think the important thing really to recognize at the outset is that there is no uniform definition of cyber squatting. It's a term that was first used in the mid 1990s before really many trademark owners even recognized the importance of the internet and the potential problems that could be caused by the registration and use of domain names that contained their trademarks. And in those early days of cyber squatting, the problem was really identified as a type of trademark infringement. And here in the United States, a form of trademark dilution, as the Federal Trademark Dilution Act had just gone into effect in 1995, really, which was coincidentally about the same time that the problem of cyber squatting even arrived. But it was obvious in those early days that trademark laws were not very well equipped to address the issues that were created by the bad faith registration or use of domain names, such as traditional trademark confusion and counterfeiting, but also new types of online activities, as you can see here, and some of which I'll be talking about in a minute with some actual cases, such as phishing, spreading malware, deceptive advertising. In the early days, a lot of pornography related to cyber squatting, blackmail and other scams that really prompted trademark owners to seek control of domain names that had been registered by others. So as I said, domain name disputes are indeed at an all-time high. And I think there are a number of reasons for that, including what you see on the screen right now, which is the coronavirus. A lot of new online scams rely on domain names. And as this Washington Post article from last September pointed out, it quoted a report from an organization called the Digital Citizens Alliance, which said, and I quote, "As long as the number of COVID cases continues to grow, scammers and domainers will capitalize on Americans," and of course it's not just Americans, "fear and uncertainty," close quote. So the coronavirus is certainly not the only reason for the explosion of cyber squatting. I think there are a number of other factors to blame, including just, in the overall increase in domain name registrations in general, the low cost of becoming a cyber squatter, the ease with which cyber squatters can hide, and I'll talk about that issue as well when I review a few important cases from last year, and really the sheer creativity, if you will, of what I often refer to as online scam artists. So of course, humans have always found creative ways to get things that they don't have, and this is real news here, not fake. A story from 2019 about a man who actually tried to use a gun to wrestle a domain name away from a cyber squatter. or a man who he thought was a cyber squatter in Iowa. But obviously that's not a viable or recommended or legal option. And so that's really where domain name disputes come into play, where domain name disputes domain name dispute policies arose in the 1990s. They were created essentially as an alternative to using traditional laws, including traditional trademark laws, against cyber squatters. And these are contractual policies, um, and especially the UDRP, the Uniform Domain Name Dispute Resolution Policy. They provide, as the name states, uniform rules for domain name disputes worldwide. And as a result, they eliminate jurisdictional issues and they offer relief in a much quicker, usually, and much less expensive manner than going to court. So in particular, the UDRP has proven to be extremely popular for trademark owners. It was created in 1999 by ICANN, the Internet Corporation for Assigned Names and Numbers. And ICANN, as you may know, is essentially a nonprofit entity responsible for large parts or most parts of the domain name system as we know it. So a typical UDRP case can be filed at any of the providers, including, as Barry mentioned, of course, the newest provider, the one who's hosting our event today, the CDRP, for $1,050 US dollars, which is less than you see as the typical filing fee, even on the slide here. A common UDRP dispute is resolved in about 2 months. All of the proceedings take place online without the need for expensive and time-consuming litigation procedures, such as discovery and motions and hearings and trials for better or worse. So the UDRP applies by contract to .com, and most other top-level domains, does not apply to .ca. As Tina will speak to in a moment, there's a different policy for .ca disputes. But the UDRP does apply to all of the so-called generic or global top-level domains, of which there are well over 1,000 now, including, of course, .com, .net, and .org. And a decision under the UDRP by a UDRP panelist is a part of this overall contractual system, and the registrar of the domain name is required to technically carry out or implement a transfer of the domain name if that is the decision that has been reached in a UDRP proceeding. So as we've mentioned a couple of times, you can file complaints at any of the ICANN approved service providers. Of course, CDRP is the newest provider, and as you'll see in a minute, has been growing significantly in its caseload since the first year of 2019. WIPO, the World Intellectual Property Organization based in Geneva, helped draft the UDRP and today is the largest of the providers. The National Arbitration Forum, or simply the Forum, formerly known as the National Arbitration Forum, based in Minneapolis, is the only US provider, has the second largest number of cases. And the others that you see on the screen here are based in Prague, multiple offices in Asia and in Jordan. But what's important to keep in mind, and sometimes I find myself explaining this to clients, is all of these UDRP service providers administer the same policy. No matter where the trademark owners are located, no matter where the domain name registrants are located, no matter where the domain name registrars are. So a trademark owner can file a complaint with any UDRP service provider. So this chart shows a bit of data about just really sort of a snapshot, if you will, of some UDRP cases in the past 2 years since CDRP began accepting cases after it was accredited by ICANN. And as you can see, as I pointed out, WIPO is receiving by far the largest number of cases. But as I said, CDRP is really growing significantly with more than 10 times the number of UDRP cases last year in 2020 versus 2019. So what's important to keep in mind, and this chart shows the outcome, the typeface may be a bit small, but the important information from this slide is to understand that the overwhelming majority of decisions under the UDRP are in favor of trademark owners who file the complaints. Anywhere from 80 to 90+% result in decisions ordering the disputed domain names transferred to the trademark owners. That's what the dark orange is indicating there. Only really in a small number of cases are UDRP complaints denied, which allows the current registrants to keep their domain names. And really, in my experience, I think by far most, not all, but most denials are really the result of complaints that either maybe should not have been filed in the first place, or that failed perhaps to include all of the factual and legal relevant arguments. So as we can talk a bit later, maybe during the Q&A if we have time, the burden of proof is always on the trademark owner filing a UDRP complaint. So if the trademark owner fails to meet its burden on any part of the UDRP's three-part test, then the panel will have to deny a transfer of the domain name. So the key point here is simply that drafting a thorough and strong complaint is not only important, but it is essential. So we could spend hours talking, just about how the UDRP works. And unfortunately, we have limited time and maybe attention. So in the interest of time, the most important thing to understand is that the UDRP simply has this three-part test here. So what this means is when filing a complaint, the trademark owner has to prove by a preponderance of the evidence that the disputed domain name is identical or confusingly similar to a trademark in which it has rights. That's the first part of the three-part test. Number two, that the registrant of the domain name has no rights or legitimate interests in it. And number three, that the domain name was registered and is being used in bad faith. And I'll walk through all three parts of this in a little more detail in just a moment. What's also important to keep in mind is while, of course, we have the UDRP and the UDRP rules, and each of the providers, including CII DRC, has its own supplemental rules, we have now, close to 22 years worth of decisions, literally tens of thousands of UDRP decisions that have added a great deal of detail to this three-part test and have established some important precedent. So just digging down a little bit deeper into some of these elements. First, just to talk about the first element of the UDRP, as I said, it says that the complainant, which is the person or company that files the dispute, has to prove that the domain name at issue is identical or confusingly similar to a trademark or service mark in which the complainant has rights. So interestingly, this although it's the first part of the UDRP test, it actually really consists of two parts. First, the complainant has to prove that it has rights in a trademark, and that is sometimes an issue. And then second, that the domain name in dispute is identical or confusingly similar to that trademark. Now, interestingly, the UDRP says nothing about where those trademark rights have to exist. So in other words, a trademark owner can have rights in Canada, in the United States, in the European Union, or really, in almost any country or geographic region. And as I said before, that's regardless of where the parties are located. It also, interestingly, doesn't matter, at least not for the first element of the UDRP's three-part test, when the trademark owner's rights arose. This first element does not speak to timing. That can be very important with respect to the second or third elements of the UDRP's test. And in general, I think the most important thing about this first element is that it's typically not a difficult task for a trademark owner to establish its rights. But if you fail to do so, then you fail the UDRP complaint. Usually the more substantive part of this first part of the test is the identical or confusingly similar language. What's important to know here is that generally when you compare a domain name to a trademark, you disregard, in most cases, this is what UDRP precedent says, the top level portion of the domain name, such as .com, .net, or .org. And also a domain name that consists entirely and only of a trademark is usually considered identical to that trademark. That's a lot less common than it was sort of in the early days of cyber squatting. The more common issue is deciding whether a domain name is confusingly similar to a trademark. And this bar according to most UDRP panelists, is pretty low. Typographical variations of a trademark are almost always found to be confusingly similar. And as a general rule, UDRP panels find that a domain name containing a trademark plus another word is still confusingly similar in most cases, even if it's a pejorative word such as sucks or a more offensive vulgarity. I just published a video a couple weeks ago about a UDRP case involving the F word plus a company's trademark. So moving on to the second element of the UDRP's three-part test, this element differs in a very important way from the first two parts because it requires a trademark owner to really prove a negative. Specifically, the domain name registrant, the trademark owner has to show that the domain name registrant has no rights or legitimate interests in the domain name, and proving a negative is not always easy to do, especially when a trademark owner may have little information about the domain name registrant's true identity or background or some other actions that it may have taken. So fortunately, UDRP precedent makes clear that trademark owners can actually shift this burden in appropriate cases onto the domain name registrant. As you can see on this slide, there are three ways in which a domain name registrant can prove its rights. I won't just repeat the text on the screen. But under pretty well-established UDRP precedent, because this test relies on information that is primarily within the knowledge or control of the domain name registrant, if a trademark owner makes out a basic case against rights or legitimate interests, then the burden of production on this element shifts to the domain name registrant. And then finally, the third or bad faith element of the UDRP, the one that usually gets the most attention, this contains a very important word, and that is the word and. So as you can see specifically, the language of this element of the UDRP says that a trademark owner has to prove that a domain name has been registered and is being used in bad faith. Now, there's some interesting history in UDRP decisions through the years about the importance of this word, but the consensus view is that it means a trademark owner really has to establish bad faith at two different points in time. Bad faith when the domain name was registered and bad faith use now. So this is important because it means that a trademark owner, in some cases, may fail to prove the third part of the test, even if a domain name is currently today being used in bad faith, if it was not registered in bad faith and vice versa. So there are four examples of, and they are just examples of bad faith, as you can see on the screen here. The fourth one, relating to a likelihood of confusion is one that maybe arises perhaps more than any of the others. And another important note here is, as I said just a moment ago, these are just examples of bad faith. So they are non-exhaustive examples. And so a trademark owner can establish bad faith even if a domain name registrant has not acted exactly according to any of these definitions. So through the years, UDRP panels have found bad faith in many other circumstances. Perhaps the most common is what's referred to as the passive holding doctrine, which occurs when a domain name is not actively being used at all. And this doctrine usually arises only in the context of especially strong trademarks. So I really want to spend the remainder of my time before turning it over to Tina to talk about the Canadian policy to look at a few important and interesting UDRP decisions from the CII-DRC in the past year. And the first case I want to talk about, and as you can see, involved the domain name unemployedprofessors.org. And the reason I'm talking about it is because it raises an important issue related to that first element of the UDRP that I was just speaking of a minute ago. So in many cases, as I said, the issue usually is whether the disputed domain name is identical or confusingly similar to the relevant trademark. But as I also said, the first element of the UDRP includes this fundamental issue as well, which is whether the complainant actually has trademark rights in the first place. Because if there is no trademark, then you don't even get to the point of analyzing confusing similarity and comparing the domain name to anything. So what's important to note about this case is that it involved an unregistered trademark. And that's okay because the UDRP does not specifically require a complainant to own a trademark registration, only that it possess trademark rights. That's what the policy says. So a complainant can hold common law or unregistered trademark rights, which is what was asserted in this case over the mark unemployed professors, which the complainant said was used in connection with the referral service between writers or unemployed professors on the one hand, and students or other clients who needed their essay writing services. So the complainant said that it had operated a website at unemployedprofessors.com since 2011. And in this case, the respondent's domain name, unemployedprofessors.org, was registered 8 years later in 2019. The respondent said that it acquired the domain name only after it did not find anyone with a trademark registration for unemployed professors, and also apparently after its own application to register the name as a trademark was denied as being descriptive. So the registrant of the domain name here apparently thought that there would be no trademark issues in using the domain name. So in any event, let me just read the relevant portion of the UDRP decision that addressed whether the complainant actually had trademark rights in the unemployed professor's mark. So here's what the UDRP panelist wrote, and I quote, concerning the initial aspect under the first element, and being that this is an unregistered or common law trademark, to establish rights for purposes of the policy, the complainant must show that its mark has become a distinctive identifier which consumers associate with the complainant's goods and or services. The decision goes on to say, I'm still quoting, the complainant provided evidence that its business under the domain name unemployedprofessors.com has been covered across the internet in websites such as Slate and Business Insider and National Post, to name a few, with some of this coverage dating back to 2012. The evidence on record suggests the complainant has been in business since at least 2011, using the unemployed professor's name and mark, and that its business stretches beyond Canada, suggesting that at the very least, its level of activity is not trivial. Under these circumstances, and as per evidence on record, the panel notes that although the term unemployed professors involves two common dictionary terms, the panel considers that in combination, they are capable of becoming distinctive and can confer rights for UDRP purposes. So in other words, the UDRP panel found that the complainant had established common law trademark rights. I'll just add here that in my experience as both a panelist and as party's representative, I think additional evidence of common law rights is usually more appropriate than what seems to have been established here. But the bottom line to remember is simply that under the UDRP, a trademark registration is not required, and common law trademark rights, if you can establish them, are indeed sufficient. So the next UDRP decision I want to talk about today, I've included because the result was something that really doesn't arise very often, but it's still important to keep in mind. This was a split decision involving multiple domain names, two domain names, one of which in this case the panelist ordered transferred to the complainant, and the other of which it allowed the respondent to retain. So according to the decision in this case, the complainant was an author and publisher of instructional books and other materials to help people learn the Greek language. It had been in business since 1987. Apparently it had a trademark at one point in Greece for Deltos that expired, and then the complainant filed a new application in 2009 that was apparently still valid as of the date of this trademark registration, as of this complaint rather. So the respondent in this case, according to the decision, registered these two domain names, communicateingreek.com in 2005 and deltosbooks.com in 2007, and used them to sell books about the Greek language. And apparently, although the details are unclear, it looks like from the decision that the parties had some sort of a business relationship with each other at some point in time. So like the unemployed professors case I was just talking about a minute ago, this case actually also raised some issues of common law trademark rights, which the complainant asserted for the communicate in Greek phrase. In this case, the panelist said the complainant had provided, quote, just enough evidence to support its claim on that issue. but the trademark rights apparently were not strong enough to prevail on the second or third elements of the UDRP, and on communicate in Greek. And here's what the panel said about the bad faith element. Again, just to quote from the decision itself. The panelist said, with respect to the domain name communicateinGreek.com, respondent asserts that it did not exhibit bad faith, as this domain name is generic in nature. Where a domain name has a descriptive or generic meaning and is used in relation to such meaning, a respondent may be found to have acted in good faith. Complainant has not demonstrated that its rights to the communicate in Greek mark extend beyond reference to its own books, certainly not as of the 2005 date on which respondent registered its domain name. And so on the balance, the panel finds that respondent's use of the communicateinGreek.com domain name to refer to its range of Greek language products does not amount to bad faith. Now, on the deltosbooks.com domain name, which was also in this case, the panel reached a different conclusion, based in part, apparently, on some evidence of actual confusion among consumers who had contacted the complainant when they were intending to contact the respondent. So bad faith was much more evident with respect to the deltosbooks.com domain name, especially, as I said, given that one of the four enumerated ways in which you can establish bad faith is to show a likelihood of confusion. In this case, there was actual confusion. So the takeaway here from this case is to remember that this was a split decision. Does not happen very often, but trademark owners should remember that, even though the UDRP may allow you to include multiple domain names in a case, and I'll talk about that more in just a moment with respect to another decision, it's still necessary to establish all three parts of the UDRP test with respect to each and every one of the disputed domain names in the case. So while the communicate in Greek decision was pretty unusual, this next UDRP case raised a pretty common issue in domain name disputes, and that's phishing, which, if you're not familiar with the term, really is defined as the fraudulent practice of sending emails purporting to be from reputable companies in order to induce individuals to reveal personal information, such as passwords or credit card numbers. So in this case, the UDRP complaint was filed by a charitable organization established in 2015. Forgive my pronunciation if I'm mispronouncing it, known as the Yanai Tadashi Foundation. Apparently, this organization provides scholarships and support for Japanese students who are studying in the United States or the United Kingdom. And it was funded, interestingly, by a famous Japanese billionaire, Yanai Tadashi, who also apparently is the founder of the largest clothing retailer in Asia. So according to the UDRP decision in this case, the respondent registered the disputed domain name in 2020 and used it to send numerous phishing emails that were signed by legal advisor, and offered the recipients of these emails highly paid speaking engagements at an upcoming event that was supposedly being hosted by the complainant in Japan, when in fact there was no such event. So it's unclear from the decision exactly what the respondent hoped to gain. But as I said before, in similar cases involving phishing attempts, domain name registrants try to get credit card information or passport information or some type of other personally identifiable information that might be of value. In this case, the UDRP panelists said that this was a pretty easy case. And again, just to quote now from this decision, the panelists said, based upon all of the circumstances of this case, the panel concludes it to be highly unlikely that respondent registered and used the domain name with any intent other than to seek commercial gain through a phishing scheme, which is based upon impersonation of the complainant and a likelihood of confusion with its mark. As such, respondents' actions implicate the bad faith element of the UDRP and thus satisfy complainant's burden of proof to show that the disputed domain name was registered and used in bad faith under the policy. This, by the way, is consistent with what's set forth in a document from WIPO called the WIPO Overview, which is intended to sort of establish some consensus views on the UDRP. And that document directly states, by the way, that phishing can never confer rights or legitimate interests on a respondent under the second element of the UDRP. and that phishing is manifestly considered evidence of bad faith. So the last case, the last UDRP case from the CII DRC that I want to talk about involved 3 domain names. It was not a split decision like the earlier case I mentioned. What's interesting, and the reason I'm including it here, is because there were 3 differently named registrants. So it raised the issue of what is called consolidation, which refers to including multiple domain names in a single complaint when there are multiple registrants. At its most basic level, I guess I'll just point out, the UDRP makes clear that it's perfectly fine to include more than 1 domain name in a complaint, as long as, to quote the UDRP rules, they're all registered by the same domain name holder. So in some cases, that's very straightforward. I filed the largest UDRP complaint that has ever been filed a number of years ago for one of my clients that involved more than 1,500 domain names in one complaint. Despite the sheer numbers, it was a rather straightforward case, and all of those domain names were actually registered to one individual. Today, however, thanks to privacy services and the European Union's GDPR, the General Data Protection Regulation, today, a lot of registrant details and even registrant names are not always publicly available. So many cyber squatters masquerade their true identities. They use fictitious names when they register domain names, or even random characters on a keyboard that I've seen. And so those cases raise the issue of whether we're dealing with the same domain name holder. That is one person or entity responsible for all of the disputed domain names. And that's exactly the issue that arose in this case. So as you can see, it involved, from the slide here, it involved 3 domain names, each of which contained the complainant's Majuri trademark. Again, pardon my pronunciation or mispronunciation. It's a trademark used in connection with jewelry. So it appears from the decision as if 2 of the domain names were registered using the popular domains by proxy service from GoDaddy, which allows domain name registrants to hide their identities when they register their domain names. There's nothing inherently wrong with that, but these privacy services are often used by cyber squatters to hide themselves. So after the UDRP complaint was filed, the registrar lifted the privacy veil and provided what's sometimes referred to as the underlying registrant information, which actually showed that there were 3 differently named registrants for the 3 domain names. So according to the UDRP decision, the complainant argued that all 3 identities were falsified to hide illegal activity. And the illegal activity apparently was a website that looked like the complainant's website, also offering jewelry for sale, but actually not delivering it. So the panel in this case noted that although there were 3 differently named registrants, there were a number of similarities among them. Similar email addresses, similar dates of registration, unusually similar spellings, fake street addresses, fake phone numbers generated from the same style of random adjacent numbers on the keyboard. The domain names use the same name servers, and there were obvious similar inconsistencies between the city and provinces for each of the respondents. So as a result, in this case, the panelists said, actually cited back to the WIPO overview on this issue, and the WIPO overview says that where, to quote, where a complaint is filed against multiple respondents, panels look at 1, whether the domain names or corresponding websites are subject to common control, and 2, whether the consolidation would be fair and equitable to all parties. The overview goes on to say that procedural efficiency would also underpin panel consideration of such a consolidation scenario. So in this case, the panel found that all 3 of the Majuri domain names were indeed subject to common control, and that consolidation would be fair and equitable. And as a result, it meant that the trademark owner was effectively able to kill 3 birds with 1 stone, allowing the case to proceed and achieving a decision ordering the transfer of all 3 of the domain names, which is a huge savings in terms of both efficiency of time and money. So that really ends my portion of the presentation, at least for now. I hope we'll have some time for some Q&A at the end, but I'll hand over controls now to my colleague Tina, who As I said before, we'll focus on the Canadian domain name dispute policy, which applies to the .ca domain names. And I know Tina will do a fantastic job with that. And then I'll be back again at the end. Thank you.
Thank you, Doug. That was an excellent presentation. And as you see, by the quick treatment that I will give to some of my slides that Doug has covered many of these topics fulsomely already. And so we'll just talk mostly about what the differences are or what the interesting things are that come out of the CDRP versus UDRP. So Doug has already explained that the UDRP applies to those generic top-level domains like .com, .edu, .gov, .org being the traditional ones. And he's mentioned that, you know, we're now at over 1,000, I think the number was, of generic top-level domains. Doug is definitely a pioneer in this area, having been involved in the internet law side of things since pre-2000. That is not my background. So what's interesting is my introduction to this area of the law came through that opening up of the new top-level domains, and particularly with a dispute around the ICANN process for one of those particular domains. So it's interesting how you come to this area. My background is definitely more dispute resolution than internet law, but it is an interesting little area where arbitration or arbitration-like techniques have provided for a very efficient form of dispute resolution in a particular space. And so I quite like this area. It gives you practical access to final and binding decisions in this particular area. So we have the .ca. So unlike the generic top level to which the UDRP applies, the CDRP applies to .cas. So that's our country level domain for Canadians. And so it is the dispute resolution policy that applies to CIRA, the Canadian Internet Registration Authority. Like the UDRP, it operates contractually. So it binds parties who register their domain names through registrars that are accredited by CIRA to give out those .cas. And then those dispute resolution provisions or agreement to be bound are incorporated in those registration agreements between the registrants and the registrars. The policy is based on the UDRP, but as you'll see, not exactly the same as the UDRP. I think there were some efforts to sort of streamline some of the learnings of the previous number of years and simplify perhaps. And maybe we can discuss whether that was actually the outcome with respect to certain particular issues, at least. So it does give you access to an enforceable decision. And so here we have I've set out the scope and purpose clauses from the CDRP directly. So it doesn't apply to all disputes. You know, those of us who are used to arbitration maybe are used to having a wide scope for a tribunal or panel to make a decision. Here it's much more limited. This is the creation of a forum for those cases of bad faith registration of domain names. So these are third parties who become your complainants to bring their claims against those registrants who have already agreed to be bound by that policy. So here we have some of the concepts will be familiar to you from Doug's presentation here, that your domain name is just the main part of the domain, not including the suffixes. So this is what you're looking at when you're looking at the domain name and trying to make a decision about whether or not there has been bad faith registration. So at a high level here, the CDRP process, again, very cost effective, $1,000 Canadian filing fee, plus your single member panel. Many of these cases, in particular, where you have, one of those internet bad actors as your registrant, will not have the registrant will not participate in the proceeding. So the proceeding gets commenced, it gets filed, it gets notified to the registrant, and then the registrant has a period of time during which to respond, and oftentimes they don't. And so when a registrant does not respond, then you have the option to convert from a 3-member panel, which is the default, to a single-member panel, which is a bit more cost-effective. And that is one of the options. If you don't make that election as a complainant with a non-responding registrant, then you'll end up with a 3-member panel. Or if you have a response, then the default is 3-member panel, but the parties can agree to switch that to single. The time is very similar to what the UDRP timeline was, maybe a little bit shorter. Here it says about 47 days versus 60. It is a form of online dispute resolution. So it is all done electronically, and Barry showed you what the website looks like there to be able to do that through the CDRP. Your remedy is one of two things. You either get that domain name transferred to you if you're able to establish your rights in it, or you can have it deleted, and it's the panel's decision. And then the implementation is quite quick, 30 days from the date of the panel's decision. So as mentioned, the CIIDRC provides services for both UDRP and CDRP disputes. And the other provider for .ca disputes, the CDRP disputes, is Resolution Canada. And just roughly speaking, they split the market about 40-60, with the CIIDRC having a slightly larger caseload there. The thing that makes, I think, the most obvious unique feature or thing that is available or required part of the CDRP policy that is not part of the UDRP policy is this Canadian connection. And so the purpose of CIRA is to develop this .ca domain space sort of as a guardian, as a public, for it to be a public resource for development, social and economic development of all Canadians. So the sort of nexus of that purpose to the policy and the rules is that the CDRP requires that a complainant under the policy meet CPR Canadian presence requirements. And you can do that in two ways. You can either meet them directly, or you can be the owner of a registered trademark in the Canadian office. So unlike the UDRP, where Doug has said there's no requirement to have those rights in a particular jurisdiction, or even to have those rights be registered rights, that is different. That is a difference in the CDRP. There is a requirement that there is a connection to Canada jurisdictionally. So the way to meet that requirement directly is probably what most of you would expect as lawyers or people thinking of connections to a country. So there's the first half of the list is here. I won't go through them all in detail, but it's quite obvious that Canadians will tick that box quite easily. People who are permanently resident in Canada, or corporations incorporated here, etc. And then this is the second half of the list of particular entities that will meet that CPR requirement directly. And I had an eyebrow raised on Her Majesty the Queen, but yes, she is there as our head of state. She and her successors are also deemed Canadian, and if they want a .ca domain name, they can get one. So these Canadian presence requirements, as I've just said, you can do it directly through that list, one of those elements, or you have to show that you are the owner of a registered trademark. This creates an additional step in the CDRP process that doesn't exist in the UDRP process. So in order to initiate your complaint, you have to tick the boxes on this CPR. And that's because of this back-end requirement that in order to register a .ca domain name, you have to meet those requirements. And because the remedy is usually transfer of that domain name, you have to be able to receive transfer. So meet those CPR requirements at the time of transfer. And so there's a requirement and some paperwork that you have to do on the front end where you represent and warrant that you will meet those requirements. So the thing that makes this this has created a bit of mischief in the cases that we've seen lately, because there was Doug gave a nice long list of the various mischievous things that bad actors on the internet can get up to. And I think here is an example of how it might be possible to exploit the direct wording of the way the CDRP operates versus the UDRP by people who are registering things. And in particular, this idea of typo squatting as opposed to, which is just a variant of cyber squatting, where you don't just have the actual domain name, but you misspell it a number of different ways and register all of those misspellings in order to take advantage of people getting there. So this case, I threw in a case study before the presentation just because I thought it fit well with this particular point, where you have a trademark holder, Skechers, which I think is a strong enough brand, probably known to most on the call, maker of footwear in particular, that was disputing two domain names, one spelled correctly, one spelled with an additional T. And the issue that the panel found was that Skechers was not applying by virtue of any direct CPR. It was claiming through its trademark in its brand. And that's how it satisfies the CPR provisions for the claim. And so the panel found that it had satisfied it only for one of the domain names that was disputed, because the wording of the CPR requirement says that if you are using that trademark provision, your permission is limited to an application to register a .ca domain name consisting of or including the exact word component of that registered trademark. And even though, so the respondent did not file a response. So again, this is the point Doug raised about the complainant has to prove all of the elements, even and pass each hurdle of the test. Here, an additional hurdle because of the CDRP CPR requirements. So even if there's no opposition, the panel has to look at all of the evidence and make sure that the burden of proof has been met on a balance of probabilities for all of these elements. And so the panel found that the complainant did not, with its initial filing, have sufficient evidence that it met the CPR requirement with respect to the misspelled domain name. And when it was afforded an opportunity to file further evidence, then the panel went through the claim, the merits of the claim on the others for which they satisfied the CPR requirements, and at the end, the domain name was transferred, the one that contained the actual correct spelling of the registered trademark. So moving to that three-part test, this is very similar to what Doug went through, so I don't propose to spend very much time on it at all. But just to say that here, one of the things that I found interesting is that your first one is your domain name is confusingly similar. The same thing, no legitimate interest, and that there was bad faith registration. But the The CDRP does not have that language about being identical to a mark, which they do it one step removed. So there is a definition of confusingly similar that includes, I think, quite necessarily the identical mark, but it doesn't say it directly, which I just thought was an interesting way to try to tighten it up. So we have here just a couple of paragraphs from the policy. This is what you're trying to establish on that first element. And here there's that requirement, a temporal requirement, and Doug talked about that, to have rights in that trademark that predate the registration by the registrant of the domain name. And it has to be confusingly similar. So here it doesn't have to be identical. Here, if you had that typo, so if it, in the Skechers case, for example, if they had overcome the hurdle of showing the CPR, I don't think that there would have been any issue in terms of proving that the registered domain name was confusingly similar to the mark. It's just that those are two different parts of the test. So that's your first element. You're showing that you have, again, it's deceptively a two-part test. You have to show that you have rights and the timing of that those rights predate, and then that the registered domain name is confusingly similar. Second element, again, very similar to the UDRP. It's this proving a negative in terms of legitimate interests. So the complainant has to establish that the registrant has no legitimate interest in registering that domain name. So there's a list there of sort of the opposite of what the policy says, because you're proving that negative. But they are things that you would expect. And one of the, as I have gone through this list multiple times, I realized that I have a natural good example, which is that my last name in the Venetian dialect in Italian is used for the equivalent of small plates or tapas type treats. So there are actually a number of restaurants throughout the world that are called cicchetti. There used to be one in Vancouver, which has no connection to me, but I often have colleagues who send me pictures of these places, which is fantastically fun. If I had registered cicchetti.ca, for example, rather than Cicchetti Arbitration, which is my domain name, then it is possible that somebody who owned one of these restaurants in Canada and had rights, could make a claim or complain about my holding it. And then in that case, I think that they would have a hard time arguing that I didn't have any legitimate interests in using the name because it is, as the specific example here is, it's the legal name, it's my legal name, my surname. So just an example of how you can rebut that information. It's not necessarily a slam dunk, but for very strong trademarks that are not related to people's names or particular locations, it's fairly simple, straightforward, I think, in most cases. And then the third element is the same as the UDRP again, registration in bad faith. So you are, these are the examples, non-exhaustive list, as Doug pointed out, where the purpose behind registering the domain name was to create mischief. So this is just a reminder that the onus is on the complainant to prove the three elements. Even if there's some evidence provided of each of them, the registrant can successfully defend against the complaint if they show that they have a legitimate interest. There is a provision for costs. I think I suspect this is very rarely used. I have not actually done the research to find out how often there have been costs awarded, but this is there to deter improper complaints from being brought, because if a complaint was commenced for improper reasons, there can be cost consequences to the complainant. Otherwise, the costs of the proceeding are the ones that are laid out depending on the size of the tribunal, your admin fees and your panel fees, and it's not really an issue the way it is in other arbitration proceedings. So similar sort of proportion of cases, most of the outcome in the cases result in transfer of the domain name to the complainant. So they are successful in establishing their rights. And in very few cases, they are denied, again, often related to their failure to provide evidence on each of the three levels that are required. And so I've just got a few cases here so that just to illustrate, this one is related to FanDuel Group. The complainant's a sports betting partner. The registrant registers, and they own, the complainant owns FanDuel.com. They have the trademarks. And there's no doubt about that. The registrant, just to show that many of the original nefarious motivations listed on Doug's early slide still exist. This one, we have a registrant registering the .ca version, but showing pornographic images on the website. So the complainant brings its complaint. The registrant fails to file a response. It did not elect to go to a single member panel. So a 3-member panel looked at the evidence and found that the complainant had established its rights to the mark and that there were no legitimate interests by the registrant and that they had registered it in bad faith. So this is sort of cookie cutter. The trademark is exactly the same, and you don't have any of those complicating features. The next case that was somewhat interesting involves the Canadian presence requirements, not through a trademark. So I think most often, vast majority of cases, we're talking about trademark owners who have a registered trademark, and that's how they satisfy the CPR. In this case, the disputed domains were, the trademarks are owned by a US entity, which is the parent company, and then there is a Canadian entity, which was incorporated in British Columbia, and that was the way that the CPR was said to have been met, those requirements. And the registrant was a former employee of the Canadian entity working in Canada. And during the time that he was working for them, for Canadian Truck Protection, he registered 2 of the domain names. So the Premium 2000 is the same, the .ca is the same as the parent companies in the US. And then he also filed the other CTP warranty. Those are the names that the complainant uses to name its products, which it was able to establish were well known in the market, and it had been using those names in relation to those types of truck warranty products for a number of years, and it was in fact the leader in the market. The registrant, after registering the domains, leaves the company. When the complainant complains, he offers to sell them back for far in excess of what the cost of registering them would have been, and asserts that he is the legitimate owner. The registrant opposes the complaint, so actually files a response and says that they had no rights in Canada, so arguing this temporal argument because there were no registered marks, and says that the rights were not established prior to his registration of the domain names. And he asserts that he is the one with the legitimate interest and meets the Canadian presence requirements. The panel found that the registrant had not established that it had a legitimate interest in the marks, or that it met the CPR. And so we had a decision that ordered the transfer of the names, and the respondent has now contested that decision in court. So despite the fact that you can bring this sort of self-contained dispute resolution process for your domain names, there is the ability to appeal those decisions or to bring court proceedings if you can find a court has the proper jurisdiction. And that is what has happened here. We don't have an outcome yet on what happened with the challenge, but it's one to watch. Somewhat interesting to see if a court, what a court will do with this particular complaint. This one is another one of these multiple domain names. So we've got lots of different domain names, but we have the same registrant. So that's a simplifying factor. And the registrant, the complainant was able to offer evidence that this particular registrant is a serial cyber squatter and typo squatter, because they were able to show numerous registrations of other well-known trademark names where different typo versions of the same domain name were registered. And the panel concluded in that case that the complainant had met its onus, and that the registrant had failed to provide any evidence to rebut the conclusion that it had registered in bad faith, or that it had rights, or to prove that it had a legitimate interest in the domain names. Now these last two, these are very new cases, last week in fact. And these are interesting to me because they show that one of these differences that you need to be aware of between the UDRP and the CDRP. And this has to do with consolidation. So Doug talked through the case where the WIPO overview was referred to in order to give the panel comfort in consolidating numerous cases where the registrant was not on its face the same entity. So it's easy to bring multiple claims in the same proceedings if your registrant is the same on its face. Now that there seems to be this trend of using fake names or hiding behind domain proxies, it makes it more complex for the complainant to be able to show that it's the same registrant. So we have two examples here. This one has to do with two domain names that are that include within them the trademark Calvin Klein. It is a registered trademark in Canada, so no issues with CPR. There were, the 2 domain names were registered by 2 different people. But there were similarities in the names and addresses and email addresses and information provided to the registrar that indicated that perhaps the registrants were not actually the registrants of the names. The complainant also argued, interestingly in this case, that these were revenge domain name filings because they had previously made a complaint about this other version that incorporated their trademark. And while the panel was considering that complaint, these 2 new domain names were filed. And there seems to be a pattern there of redacting information and using aliases to avoid their enforcement. So these websites all offered, they reproduced the complainant's trademarks and the particular logos and fonts, images even from their official website to offer purportedly sale prices on their goods, but the allegation was that they were actually counterfeit goods being offered. And so the panel here looked at this argument about whether or not they could consolidate in light of the fact that the registrants on their face were 2 different registrants. And the panel said, you know, that WIPO overview is really interesting, but it in part relies on the express provision in the UDRP that allows a panel to consolidate. And there is no analogous provision in the CDRP. And so what has to happen is that the complainant needs to provide evidence of a common owner in order to be able to consolidate under the CDRP, because that is what's required under the rules. And if you do that, then the panel can use its ability to manage the proceedings, effectively, to consolidate, and there's no unfairness because it's the same registrant and it applies. And on the same day, there's a case with the same issue. So this seems to be the flavor of the week in terms of what people are doing with domain names that they're registering. This one has to do with the well-known trademark Birkenstock. There were 4 different domain names registered in and around the same time. All of them included the word Birkenstock, but on their face, the registrants were different. Again, similar patterns. So they're using people's names. The allegation was actually that the names and potentially some of the contact information were taken from previous customers. So individuals who had ordered things from some website operated by these people. And then they use those names as the nominal registrants for these websites and set up fake email addresses. I don't know if they were fake or actual, but they all followed a pattern, you know, name, 2 numbers, and they were a generic email provider. So there were definitely similarities. Again, you have the complainant arguing that the proceedings should be consolidated and referring again to that WIPO overview. And same sort of argument that this is a pattern of trying to avoid the evade the enforcement of the trademark rights by constantly changing and hiding the true identity of the registrant. And then again, the panel notes that there's a difference, or that the CDRP at least requires that the same registrant. And in this particular case, they said that the complainant didn't provide evidence that the registrant information was false. So what's different is some of the other cases, there was actually evidence that the address, for example, related to bare land, and not a place where somebody could actually live. And that there was coordination in the different elements. So this one, I think, failed because of that failure to give the panel some comfort that the registrations were false on their face, which was satisfied in other cases. So this complaint, your option is to dismiss, which is what happened. And I presume they can try again with the evidence they need, and or bring them separately. So that brings me to the end of what I had planned to say. And I think I have inadvertently answered the question that's come up on the Q&A about whether the test for consolidation is the same. But maybe what I can do is stop sharing my screen and let us transition over to Q&A, and then we can see if we address people's questions.
Thanks, Tina, and thanks, Doug. Just before we proceed into the questions, I'd just like to remind everyone that we have some good news to share. This webinar has been approved for continuing professional development credits or continuing legal education credits, depending on your jurisdiction, in the state of Georgia. The Georgia Commission on Continuing Lawyer Competency has given their thumbs up, as has the State Bar of Texas, where I should have mentioned that's where Tina is presenting from today, as well as the Law Society of British Columbia. So if you're happy to, if you happen to be fortunate to be in one of those jurisdictions and watching this webinar, please feel free to claim 1.5 credits. Certificates will be provided after this webinar, shortly thereafter. So watch for that in your email inbox. And then also, I know we've had a question about this. Will a copy of the presentations be available? And yes, they may be sent to you in a PDF format, just to reduce the size of the file being distributed. But you can watch for that. Now, Tina correctly noted that someone did submit a good question, which was whether the test is the same for consolidation, whether it's UDRP or CDRP. And I think Tina mentioned that, talked about that, but I don't know if you have anything further to add, Tina or Doug.
Yeah, maybe Doug, if you have, having done many cases under both, you're on mute.
Hopefully you can hear me now. So I can never get through a Zoom meeting without somebody failing to unmute. So it had to be me. I think really there are more similarities than differences between the two policies on that issue. What's interesting to me is, Tina, you noted that there were two current decisions raising this issue. I think, as I said during my presentation, we really don't see these tremendous cases anymore of the 1,500 domain names in one complaint, but you sure see a lot of complaints with multiple domain names, whether it's 2 or 3 or sometimes even 20 or more. And I think that's although it's challenging to identify these multiple registrants sometimes, I think it really kind of speaks, if nothing else, to the growing cyber squatting issue, which is that there are lots of bad guys out there trying to register multiple domain names. And ultimately, as I tell my trademark clients, those who can be taken advantage of will be taken advantage of. And so the best thing to do is to take some action. But I think, through the years, there's sort of been, if you look at some of the statistics, there's a little bit of up and down. as to the average number of domain names per case. But I think that data is often skewed by some of those large cases. But I think cases with multiple domain names are certainly common now.
Thanks, Doug. Anything further, Tina?
No, I think that does it. So, you just want to be careful that you need to show that there is a relationship between those registrants if they're different.
So if anybody else who's watching has questions, please feel free to indicate that. Either submit them through the chat or the Q&A feature. And while we're waiting for that, I have a question. This is a question we get asked fairly often at the office. Can a complaint that contains both .ca and .com domain names be filed against the same registrant?
In a single complaint? I think the answer is pretty clearly no. They're two different dispute policies. So if you're talking about a registrant who has targeted the same trademark owner with, say, a .com and a .ca, maybe there will be some great similarities between the two complaints that will need to be filed, but at the end of the day, two complaints will need to be filed.
You could file them both the CII DRC though.
Sure.
Right.
And I would say too, well, a couple things to keep in mind. There's this way of proving bad faith by showing a pattern of conduct. And I don't know that a pattern applies to a specific dispute policy. So what I'm trying to say is it certainly may be possible, as Tina says, file both complaints on the same day and cite the other domain name in each complaint, so that you have a further argument for establishing bad faith. But ultimately, they're separate policies. I mean, the UDRP, on the other hand, does apply to a lot of country code top-level domains. Just so happens that .ca is not one of them, but I think there are about 40 or so CCTLDs that have adopted the UDRP. Sorry to throw around so many acronyms. So for example, .co for the country of Colombia is probably one that's used more frequently by cyber squatters. So if there was a .com and a .co domain name that were held by the same registrant targeting the same trademark owner, then yes, you could include both of those in one complaint. It's just that the complaint would be a complaint under the UDRP, not under two dispute policies. I hope that made sense.
It does. And I think if you go through our website, you can see that there's clearly a choice to be made. And yes, you could file them both the same day and through the same platform through our website, but clearly separate policies apply and separate application or complaint must be filed. A question that's also sometimes comes up: can UDRP and CDRP proceedings be suspended at any point for purposes of settlement?
Yeah. Yes. I'll speak at least to the UDRP, and I believe the same is true for the CDRP. But I'll let Tina address that if you'd like to do so. But yes, what you're referring to is a settlement or termination prior to a decision, and yes, it is certainly possible to do that. It's not uncommon, actually. I have certainly, I'd like to say, experienced everything when it comes to domain name disputes, but that's not true because nothing surprises me. There's always something new happening. But it is, not unusual for, say, a cyber squatter not to respond to a demand letter or to make some unreasonable demand. And then after the trademark owner files a UDRP complaint, suddenly the domain name registrant decides that he or she is willing to voluntarily transfer the domain name. So if the parties want to agree to that, then they can agree to that, certainly.
We've received another question, and the question is about the relative benefits, or maybe it's really what we're driving at is how do you choose where to bring your complaint if it's UDRP? Given that there are 6 different entities, WIPO, and this person's asking about forum, how to elect as between those 2, but how would you make that decision, I guess, as between 6, of which CDRP is the newest?
Well, so I'll be tactful because you are our host, Barry, in the CDRP. So obviously we're happy to be here. You know, I think sometimes it's a decision that may need to be made on a case-by-case basis. I think probably at the end of the day, most trademark owners who have filed complaints before maybe are continuing to file complaints at the same provider. So there is this snowballing effect, if you will, and that's why, you know, the oldest providers have the largest number of cases being filed with them. That's certainly one of the reasons. CDRP, you know, I'm not just saying this, though it may sound like it, I think is doing a great job. There is a great website with great resources. You know, if time zones matter to you as far as being able to reach somebody in the office, and, you know, you're a US or a Canadian entity, and want to deal with somebody in one of those relevant time zones, you know, maybe it's more convenient than a provider in a different time zone. Although, of course, lots of questions are answered by email these days. So I guess I can't really express a preference other than what I've just said.
Yeah, fair enough. And I guess there may be, you know, preferences that clients have, as you're indicating, based on their prior experience.
Right.
Does a respondent have to prove to the panel to issue a finding of, or pardon me, what does a respondent have to prove for the panel to issue a finding of reverse domain name hijack?
Yeah, so RDNH, as it's sometimes called. Yeah,
another acronym, and I find, like, just like you can't get through a Zoom meeting without somebody forgetting
right.
to unmute. I can't get through a meeting without another acronym.
Yeah. So reverse domain name hijacking, or RDNH, is a creature really of the UDRP. It is, as I like to describe it, this obviously is not the language in the policy itself, but it's you know, sort of akin to a slap on the wrist against a complainant who has filed a complaint. I'm just looking at the policy as we speak. RDNH is defined as using the policy in bad faith to attempt to deprive a registered domain name holder of a domain name. And I think there's a second reference. Yeah, there is. Brought primarily, RDNH is showing that the complaint was brought primarily to harass the domain name holder, for example. It is a finding that a panel can make with or without a request from the domain name registrant, although it's usually upon request of the domain name registrant. And it's really, I would describe it as you know, one of those cases that should not have been filed in the first place. That is, if it's clear that the probably the most often I see this issue arise under the UDRP, at least, is with respect to that bad faith element that I talked about before. Because if there's not bad faith registration of the domain name, such as if the trademark owner did not have trademark rights when the domain name was registered, and this is speaking just to the UDRP, it's different under the CDRP slightly. But if I've seen cases in which a trademark owner acquired its trademark rights years after the domain name was registered. And that, in most cases, is not a UDRP complaint that should be filed, because it's really often impossible to show that the domain name was registered in bad faith. So it might be appropriate in a case like that for a panel to issue a finding of reverse domain name hijacking. Ultimately, there are no consequences under the UDRP to a finding of reverse domain name hijacking, unlike, for example, a different policy that we haven't even touched on today, the URS, the Uniform Rapid Suspension System, which was created to apply primarily to the new global top-level domains, does have some consequences for that type of activity by a trademark owner.
We're rapidly running out of time, but I note that the couple more questions have come in. A question about the award of costs. If multiple complaints are consolidated into one, would the cost awards be limited to $5,000 under CIRA, CDRP?
So normally there is no cost award in a regular complaint that goes ahead. So you've got your limited fees that you have to pay. You get to the end and your reward is the transfer of the domain name to you as the rightful owner of the mark. So unlike an arbitration, to recover your costs usually on an out-of-pocket basis if you're successful, that there's no similar provision in the CDRP rules policy. There is the costs slide that went up there was actually the provision which is meant to deter complainants from bringing inappropriate complaints. So if the registrant can show that the complaint was brought in bad faith, essentially, for some reason, then there is a possibility of a monetary sort of fine of sorts in the form of a cost award against the complainant. So I think hopefully that answers the question.
Yes, I believe so. Thank you. And looks like there's one more. Regarding the current environment and the limited visibility to underlying registrant information, can either of you speak to how trademark holders can be aggressive in protecting their brands through tools like the UDRP or CDRP? So in essence, what can be done to what more can people do to protect their brands?
Well, it sounds like the question is relates to, you know, the proverbial whack-a-mole game. You know, no trademark owner can eliminate all cyber squatting activity coming in its direction. And, you know, the larger the trademark owner, probably the more cyber squatting activity there is. So, you know, the question isn't whether you should file these complaints or not file these complaints. I think the answer is clear. You, as a trademark owner, you should to protect your business and to protect your customers. The problem will never be eliminated, unfortunately. Reading into maybe another part of the question about sort of limited visibility, I don't know if that relates to the issue that I was referring to earlier of the GDPR and privacy protection services, and, you know, the inability a lot of times to really know who the true registrant of a domain name is. The good news, if there is any, is that despite that challenge, these policies still allow you to file the complaint. A lot of times you might not have access to what I call that underlying registrant data until after the complaint has been filed. But once provided with that information, there's usually an opportunity to amend a complaint. So for example, if you learn after filing the complaint, the registrant is somebody you've encountered before, or somebody who's lost previous domain name dispute decisions, you can perhaps have an opportunity to amend your complaint with additional arguments for bad faith under that pattern of conduct that I was referring to earlier.
Right. Well, thank you. All right. Noting the time, I think we've used up our allotted portion. I want to thank our panelists for their presentations, both Tina Cicchetti and Doug Eisenberg. Really appreciate your contributions here today. And for all of our attendees, thank you for tuning in. And again, just direct you to our website, ciidrc.org, for any further information or contact details that you're looking for. And watch your inbox for emails coming your way shortly with certificates for attending today's presentation, as well as copies of the presentations themselves. If you ever have any questions, again, just contact our office. We'd be pleased to help you. And again, my name is Barry Penner, and look forward to working with you in the future. Thanks, everyone.
Thank you.
Thank you.